introduce yourself, sir?
My name's Klotz. I'm an attorney here in Pensacola, and I have a private practice. I've been practicing law for about 23 years. Moved here about 8 years ago from Jackson, Mississippi, where I had a private practice, and in the early part of my career, I was a public defender.
And then in the middle part of your career?
In the middle part of my career, I always did criminal work because I find it to be a very enjoyable part of what I do, and did litigation which involved mass torts and multiple plaintiff litigation where we sued big companies, banks.
And lately, have you done a lot of public defender work in the federal context? Or was this trial a bit of an anomaly for you?
I've always done some public defender work just because it's something that's kind of near and dear to my heart. I started out being a public defender and wanting to do this whole law practice because that's what I enjoyed doing and fighting for the underdog. And I will always continue to do that kind of work just because somebody really needs to stand up for people who can't afford an attorney. And I've always done that as part of my practice, no matter whether I'm doing mostly personal injury or, mass tort type work or whatever else. I've always had one constant through my career, and it's been doing court-appointed work, at least part-time.
And did this case find you, or did you find this case?
This case found me somehow.
So, as a journalist who was following this, it wasn't clear to us at first whether Hansen was going to be representing himself, whether it was going to be a hybrid effort between you and Hansen, or whether you were going to be Hansen's counsel. So how did it end up?
In the first trial, there was some discussion about whether or not he wanted to represent himself or whether I was going to act as counsel, and he obviously ultimately made a decision that I was going to be the attorney that was going to be making the arguments and the presentations to the jury.
So, did you feel that you won his confidence, or he realized it might be difficult to represent himself, or what triggered that decision?
If you go back and look at the records for Mr. Hansen, most of his experience in court has been in state courts or city courts or municipal courts, and I think that the thought of being in a federal system, which is complicated and is foreign compared to most state courts, I thought it was maybe a little bit overwhelming, and so he made a decision that I was going to be the attorney making the presentations.
Had he ever served prison time before?
No, not that I'm aware of.
So he's a man who talks a lot about law and that sort of thing, but do you feel that it was it had a major impact on him, or was it another day in the life? How did the instance of being incarcerated in county jail, which is often fairly chaotic and very unpleasant, what kind of impact did that have on him?
I don't think anybody...
I ask this because, from sitting in the observer area, he seems to be someone who's pretty much entirely in his own world, who kind of talks to himself, and seems to be fairly oblivious to what other people might find to be emotional experiences. So I'm just trying to get a little more insight into him personally.
I don't think, obviously nobody wants to be in jail, and I think some people may be completely thrown off their track by the fact that they're incarcerated, and I found Mr. Hansen to be very directed, and he probably would have been that way whether he was incarcerated or not incarcerated. He was driven to a goal. He knew what he wanted to do, and I don't think that he was going to be distracted by where he happened to be living at the time.
Would you classify him as a sovereign citizen, part of that movement?
I don't have any knowledge that would make me think that he's part of that movement.
I think you once said during the trial that he had more knowledge of the law in 1776 than anyone you had ever met, but his contemporary interpretations were. So can you sort of?
Sure. I mean, I think he's that's something that is of interest to him. That is the original documents that formed our country and formed our government. I think he has a very strong interest in that, and he's very knowledgeable of that. And I don't know if the developments, the developments in the last 100 years are as important as the development of the initial originating documents of our country.
What was it like to defend someone who has such strong opinions, not just about his case or his innocence or lack thereof, but really about the legal system? He considered himself an expert on the legal system. He had strong feelings. He told us, that he didn't. I mean, there was, have you ever had? Have you ever been involved in a case that was this bizarre?
I've been involved in a lot more bizarre cases than this, just from a development of what you would think to be odd facts. The thing that's unique about this particular case is to have two people who feel so strongly about their convictions that they're willing to actually put their money where their mouth is, and that they were willing to take a stand, and the chips kind of fall where they may, and they were very strong in their convictions about how they felt. And there were two people who, regardless of how you feel about their opinions personally, were willing to make a stand for themselves. And if it involved making a challenge that they did, and there were consequences, then they were willing to take that chance. And you don't frequently find people that are willing to take a stand where they actually are placing their freedom at risk. And so that is unique. It's I wouldn't necessarily, it's a bizarre, I wouldn't call it bizarre, but it is unique when you find somebody who has the courage of their convictions. Whether you agree with their convictions or don't agree with their convictions, it's odd to find somebody, it's unique to find somebody that feels that way.
Was it tough being his attorney? With someone that's, again, so opinionated about the legal system, about jurisdiction, so on and so forth? Or do you feel the collaboration was good?
One of the hard things is if somebody has a belief about how the system maybe should be versus how the system actually, a knowledge of how the system actually is. And sometimes it can be a challenge to get a client up to speed on the way the law is actually applied contemporaneously or by today's standards, when there were distinctions and very different processes back around the 1800s, where there were different standards and different rules and in place that don't really necessarily happen today in any court.
I came down here for the retrial of Kenthoven and John Paul Hansen. Didn't really happen. So bring us up to speed.
There were motions filed, I believe, on the 11th and 12th, and those motions were filed which called into question the adequacy of the indictment. And on Friday, there were some requests by the government for an extension of time or continuance in the case. And then it came to pass over the weekend that the motion to dismiss were filed. And so those things happened right on the eve of trial, right at the last moment. And they were not something that we were predicting or counting on or knew would happen at all. So it was unexpected.
So what was the outcome of those motions or rulings?
As you saw happen this morning, the judge granted the motion to dismiss. And the government only has to make a certain threshold showing before the trial starts in order to accomplish that. And they have the ability to dismiss the indictment almost at will before the trial starts. And so the judge allowed that to happen. And the indictment counts that were left are now dismissed. And since it was without prejudice, the government's going to have to make a decision about whether or not they're going to re-indict on any offenses or maybe not on anything at all.
Bring me up to speed on what's happened with the trial in the last 4 or 5 days. And I also kind of want to know your reaction personally. Were you surprised at the turn of events? So what's gone on? What does it mean for your client, Hansen? And is this a cause for celebration and champagne? Have you won a victory? Or do you remain somewhat skeptical?
The events of this week, or the events of last week, were really started developing on Friday when the government asked for a continuance late in the afternoon on Friday, and Judge did not grant that. It was denied, and so the trial was still set. And knowing that the trial was still set, I think the government decided that they needed to go ahead and essentially take a break in the case, file a motion to dismiss, and that way they would have time to look at it, whatever it was that they needed to look at before they continued with the prosecution. The dismissal that was filed and over the weekend and then Judge Rogers heard this morning is somewhat potentially temporary because it's without prejudice. And so when a dismissal is granted without prejudice, if the government feels that it's warranted, they could re-indict either or both of the defendants at any time. So it's a temporary cause for them to be happy that they're no longer under a federal indictment with the anvil hanging over the head of not knowing whether or not they could be re-indicted at any time.
So do you think that's the government's purpose? Like, okay, we've made our point, we've spent a lot of money on this trial. Obviously there was tremendous amounts of work on your part, on the attorney for Hoven, but the efforts of the federal government were amazing in their breadth and thoroughness. So, what's going on here? What's your best guess, and what's your strategy?
The strategy right now for Mr. Hansen is to try to see how soon we can get him out of prison or out of jail. And that's the next step, is to try to see if we can seek release for him at this point, because he, as you know, he hasn't been sentenced yet on the contempt convictions from the first trial. But now that what I would call the meat of the indictment has been dismissed, it seems much more reasonable to ask for a release at this point for him. And I would feel if he did not have a conviction that was unsentenced hanging over his head, that he would probably have a much better chance to seek release. So we're just going to have to petition for that and see if we can convince the judge that he would be, a good candidate to come back upon sentencing, and that there would be no issue of, failure to appear. So first job is to try to get him out. And then as far as a strategy after that, there's only one thing you can really do, and that's just sit and wait and see if he gets re-indicted or not.
What were you thinking about doing differently in the retrial than had been done in the trial?
Well, as you know, Mr. Hansen made a decision that he was going to do the presentations to the jury himself in the second trial. And so I was acting as standby counsel in the second trial, and he wanted to be the person to communicate with the jury, which is every person's right that's been accused of a crime in our country. If they wish to represent themselves by being the one to present to the jury, they're allowed to do that. And so that question is really better one that he could answer. I know that he took very good notes in the first trial and had a very good plan for what he was going to do in this trial, and how he may have made a different presentation than I did in the first trial, I don't know yet.
Would that have taken more time?
To present the case to the jury, having a layperson do it, I think so.
There was a few jaw-dropping moments in Hoven's testimony, and there was a few jaw-dropping moments in Hansen's. but probably none larger than the other trustees made me do it, but I can't really tell you their first names because I don't really know their first names. That's something that, for those of us who are observing the trial, we'll never forget. The discussion of, I'm used to boards and nonprofit boards and trusts and, some of the politics that goes on, but could never figure out what he was saying, and it seemed to be utterly and entirely a lie because it was so incredulous. So, for him to say, well, I don't live here, or I don't need to get a driver's license, those are things that are unique and maybe defiant or eccentric, but the discussion of the trust or the nominee trust was just fantastic.
Let me draw an analogy, I suppose, or maybe not really even so much of an analogy. And the way I took that particular testimony to be is if you were participating in one of the boards that you are a member of and you're outvoted, but you still have enough respect for the board to abide by the decision of the majority, wouldn't you be in the same position?
Very much so. But when asked if I forwarded emails or who there were or how many there were, I make it a big point to not only know the names of my fellow board members, but quite a bit about them. I study their backgrounds, I figure out ways we can work together, where we are allies, where we might be in disagreement. It just seemed to be a fantastic and utter lie, and eroded credibility. And there were other things that Hansen said. Again, some he clearly said because that was his philosophy, and that was clear to the jury, and that was clear to the observers. But other things he said just did not add up, and I would imagine that would make it difficult for his counsel.
There's always hurdles to overcome in any trial, and probably the most nervous you'll ever see a defense lawyer be is when their client takes a stand. And I think the jury gives a pretty broad latitude to people who are testifying for a long period of time and may have some inconsistencies in what they say. And sometimes they don't. But I think that when you see somebody testifying for a long period of time that's a layperson, that has a complicated case, that there's always going to be something that you can pick apart. And I think that's why your job as an attorney is to try to make the jury understand that the person's a human being and may not be able to regurgitate facts from the stand without notes, without reference, that over a period of time that may have covered years and years and years, and that there's some leeway for potential inaccuracies, as somebody says. And when you're compressing into a couple hours worth of testimony the events that may have occurred over a 5 or 6 year period. But yeah, I mean, you always have to be conscious of the fact if your client says something that's inconsistent with what they've said before, or if they say something which can be taken a different way, because I hear you taking the testimony one way, and when I heard that same testimony, I had more in mind of thinking along the lines of what I said, is that you have several people on a board, you may disagree with them, and you may vote differently than they do, but in the end, you've signed on to be part of a board that you're going to support their decision, whether you agree with it or not agree with it. And I took that testimony a different way than I think what I'm hearing you ask about. So,
let's get a little technical.
okay.
What type of legal language might have, in this case, derailed the government's case to the extent that it they ended up with an acquittal. Was there outside counsel, outside of you and Attorney Keith, that brought some expert opinion or found something that you all didn't find? And did that really make a critical difference here? Because again, the government spent so much time and so much money in preparing their case, and it's just like, again, for a lay person, what seems to have happened is there was some small linguistic or semantical items that came up about the nature of the indictment, and all of a sudden, pow! The prosecutor wants an extension, the judge doesn't grant it, and for some reason the towel got thrown in. It just doesn't make sense for the layperson who witnessed the intensity of the trial and the tremendous intelligence and sweat and effort that all of you put in. And then whoever it was, the United States Justice Foundation, finds a couple of problems with some phrasing, and it's full stop. Can you explain that to the ignorant masses, me?
Well, if you'll remember, part of my closing argument in the first case and part of my theme in the first trial was that I was asking the jury whether they were going to penalize somebody for using a legal process to challenge a position. And the government had their position that they were entitled to the property, and Mr. Hoven and Mr. Hansen had a belief that they had a right to challenge that forfeiture. And so the question became, and my theme became in the defense, is that are you going to punish somebody for attempting to use a legal process? And what I think came to bear at the end of the first trial is that there was some research done on that, and then some briefing done on it. There was the briefs that were filed last week, and there's some case law that suggests that if somebody is legitimately attempting to use the legal process to accomplish a goal, and they are filing legal paperwork to do that, then it would be inappropriate to charge somebody that's attempting to affect our legal process, our civil legal process, to charge them with mail fraud. And so I think that was at the heart of the motion that was filed by Mr. Hansen the day after Mr. Hoven filed his, and the two motions that were filed were a little bit different. And then Mr. Hoven joined into the motion that we filed, I believe it was on the 12th, if I remember correctly. And so the case law actually supported the kind of the theme, and so that was developed in a way that wasn't just an argument. It was actually some supporting case law that says, hey, if you're trying to use the legal process, then you shouldn't prosecute somebody for trying to use the legal process in a civil way. And so I think those cases were the basis for the government's request for continuance. And then those cases were at least some part of the calculus that the government stated in their request to dismiss the case. Is there something more to the reason why the cases were dismissed today? I don't know the answer to that question. I just know the stated reason, but there is certainly enough teeth or enough to hang your hat on to use those cases that were presented fairly recently to the court to dismiss the case.
So, the casual observer could say the federal government might have different and more important and more timely trials to direct their efforts at. But then you look at how much effort's been put into it and how much is invested. You might say that there's a factor of burnout here because there's so much intensity around it. All kinds of guesses. But we spoke this morning. We spoke for moments. But you sort of said to me, no, there was some real stuff happening here that caused a pause. And I think you made a reference to some other case law that might have had some bearing on this.
Well, the request Mr. Hansen made this morning when he was addressing the court was to dismiss the case with prejudice, because at this time, the case is dismissed without prejudice.
Help the layman. What's the difference between the two? It sounds like dismissing the case without prejudice is a good thing.
A dismissal is a good thing in general, but if you are a criminal defendant, you would much rather have a dismissal with prejudice. When a case is dismissed with prejudice, the case doesn't come back alive and it can't be reprosecuted. If the case is dismissed without prejudice, then there's always a possibility, again, something hanging over your head that the case could be re-indicted at some point.
How often does that happen? Routinely or rarely?
This is a unique case, and so I wouldn't, I'm loath to say that it would fall with any particular rule. I can tell you that in almost all cases where there's a hung jury, there's at least one retrial. And so the fact that there's not a retrial of this case after the first hung jury is a little bit unique. And the fact that there was actually a dismissal of the substantive charges after they've already gone to the effort of trying the case the first time is very unique. So I would say, how often does it happen? Not frequently. The retrial almost always happens, but the way that this case is played out almost never happens. So the Durr case is a case that talks about the distinction between a dismissal with prejudice or dismissal without prejudice, and one of the things that case talks about is that there should be a consideration of whether the reasons given by the government in an instance like today is sufficient to sustain a request to dismiss with prejudice. And that's what Mr. Hansen did in court today. When you were there, he talked about the fact that he was asking for the case to be dismissed with prejudice as opposed to being dismissed without prejudice. And the benefit to him of a dismissal with prejudice is that he couldn't be retried for these cases. And the Durr case says that there should be some attention given to the reasons why the government is asking for the dismissal. And if the reasons why the government is asking for dismissal are adequate, then they can dismiss the case and then come back at a later time. And if the reasons why the government, and on the other hand, if the government is asking for the dismissal to happen for reasons that really are not adequate or purely strategic or because they haven't gotten the case together in time, then that may not be enough for the case to be retried. That's an unanswered question that we've got right now. That'll be something certainly that'll be brought up if the case is ever re-indicted. Whether there was an adequate reason, in fact, for a dismissal will be something that I'm sure will be challenged.
This was a federal trial. Because it's a federal trial, is it automatically more important? Do you feel like you're setting precedents? Are the rules of play that much different than state or county?
I would say there's that much difference between the state and the federal system as far as that goes, because there are many more people that are touched by the state system. It certainly is always more formal, and it feels different in federal court because it's a much more formal venue, but it touches probably less people. And the state court system, there may be an outcome in a state court system that's equally important, but with maybe less fanfare, but it might touch a lot more people than what happens in this kind of case. So it feels more formal in federal court, but is it more broad-reaching than a decision in state court? It's hard to answer.
So my imagining what you had to do to mount what I thought was a stunning defense for Hansen.
Thank you.
During this period of time. So one is, I imagine you having a rather eccentric client, and that took some negotiation. The second, I imagined, was that it took a lot of focus, because in some ways you must have been playing catch up, because you were up against the federal system, where they had put in hundreds of thousands of dollars worth of work over a decade and a half, and they had marvelous use of technology. It really was a CSI forensics display. The quality of the audio was exceptional. The visual displays, the sheer energy of the prosecutorial team and Tiffany Eggers. But there was another factor too that I was curious about. There was so much noise and static because the supporters of Kent Hovind, and by association Hansen, were a vocal lot. They were particularly noisy on the internet. So every day, if you wanted to be, you would be treated with various video interviews, with audio only. There were bloggers from various sides of the issue investing in creating thousands of words, offering many opinions. There were some very colorful pastors with big followings who were weighing in on this. There were some right-wing radio talk show hosts who had scathing words, and there was also some, folks who were offering, very earnest, sympathetic, heartfelt responses. Most of this was towards Dr. Dino or Kent Hovind. So, for you to have kept up with all this, probably would have been a full-time job to listen to the buzz. To what extent did you follow this either out of interest or perhaps in trying to learn something? And to what extent did you want to or have to keep yourself insulated and focused on the trial? Because my point as a journalist, when I wrote about this, I said, this stuff that's going on, the Hovindicators as they were called, the Free Kent Hovind movement, it's all very well and good, but basically it doesn't have anything to do with the outcome of this trial. Maybe I was right, maybe I was wrong. Do you think I was right? Do you think I was wrong? Do you think the movement and support affected the jury, affected the government? Do you think that the Free Kent Hovind movement kind of won? Or do you think it really was a lot of hoopla and noise, and ultimately it boiled down to skilled craftspeople doing their thing in the courtroom setting and in your offices and chambers?
I didn't follow any of the social media that was going on during the course of the trial. To me, really, once the trial starts and the jury is selected, there's only 12 people that really make a difference in the case at all. And they were all very well insulated by the court system from any type of outside influence, hopefully. That's the idea, obviously. They weren't sequestered in a hotel like you see sometimes, but they were instructed very thoroughly by the court on what they could and couldn't do. So I think that the jury always seemed to be in compliance with what they were asked to do, and once the trial starts, it's really only 12 people whose opinions make a difference in the case at all. So I didn't really focus on the social media or what was happening or anything that may have been going on outside of the courthouse, because it really just didn't affect the decision of what the jury was going to make.
All right, but help me with the bigger picture. So these days when people go to the doctor says, well, you can reset this bone. And the person says, no, but I did this on Google, and I looked at this, I looked at this, I looked at that, and you're wrong, and you look at my knee. So, I mean, how is, and this was really my first experience with the blogosphere. I'm, a classical, old school filmmaker, journalist, and, not used to this kind of like hoopla. And there was vulgarity, and there was a lot of, there was taunting and personal comments and, people making fun of each other across the line. It was a remarkable spectacle, something like schoolyard bullies or kind of like third grade brawl. That's what it kept reminding me of. And then there was a lot of real expert opinions and a lot of factual material that was presented. Is this new system of delivering attempts at justice or law, is it going to change the face of the legal profession, just as it's in many ways changed the face of the medical profession? Does it make a difference in terms of the kind of insurance that you have to cover? Do law firms need to be stay more on top of social media?
My firm is pretty involved with social media, but at least as far as the trial goes, it was very difficult to tell who the people were that were out there being opportunistic and finding a platform to speak on because of the notoriety of the trial, and who were the people who were really being genuinely supportive. And so I would say that most of the people that I had contact with, not all, but most of the people that I had contact with were people who had genuinely strong, sincere feelings about the propriety of the challenge to the government that Mr. Hoven and Mr. Hansen were doing. And so my experience with the people who were being a little bit more on the, in the schoolyard bully type of vein that you're talking about, and the people who were being maybe a little bit more brash, were not the people that I was really paying attention to. And I don't know if those people were being opportunistic because it was a big media platform, and they had an opportunity to be heard. But most of the people that I ran across were being sincere in their support, and were doing it in a pretty respectful way.
Did you notice from your vantage point that there was more security at this trial than maybe some others that you have worked?
I think because of the sheer number of people that were out front, that the court asked for, it appears the court asked for more security to become, on scene. And that was unique and probably only prompted just by the sheer number of people and the fact that there were people being vocal. And the court was just being cautious, I'm sure.
Were you aware that there was some remarks that could have been interpreted as threatening made against the judge and Ms. Eggers?
No.
I think that was another thing that prompted increased security because, again, those were made on the internet openly and passed on to the federal marshal. So.
Sure. I mean, anytime if there's a threat made, I'm sure that that's going to be taken seriously by the U.S. Marshals.
What are the bigger lessons here? Do you think that that Hansen and Hoven conspired together for profit out of greed, or do you think they worked together or independently out of the strengths of their convictions, be they political or religious or philosophical?
I think if you look behind the money that was coming in at the time of Mr. Hoven's heyday, that you will see that most of the money was plowed back into the ministry. And I haven't seen any evidence that he lived an extravagant lifestyle or wore tailored suits or had a Bugatti, or I think he drove a modest car that he probably had 200,000 miles on, and had a modest home that he lived in with his family. So I think the argument that this was done from a basis of greed is misplaced. And I think that the reason for the links that were gone to try to challenge the forfeiture were purely based on conviction and not done out of any desire to make a profit.
Just let's touch for a second on Hansen's character. Hansen, in some ways, to some of us, was almost a caricature. Because when he said he was X number of years old and he read the encyclopedia 3 times or whatever, and his obsessive convictions, which aren't necessarily so different than myself as an environmentalist or someone else with strong feelings. But he was a hard person from the observer platform to get to know. And many times he was off on the side of the, in the box, seeming to almost like talk to himself and play with his hands and rock back and forth in almost a rabbinical style. He was odd. What was he like up close and personal? Did you get to know him as an individual, and do you have any recollections?
I think what you would find is that the focus that he had and his decision to go to trial in this case is probably something that is consistent throughout his life. He has very strong feelings that are, whether you agree with his personal convictions or don't agree with his personal convictions, are strongly held, and he's not somebody that I found was going to be intimidated into doing something that was not in line with what his convictions were. And so he may be unique in that way from some people who don't have the will to take a risk that you take when you go to trial. Going to trial is a humongous risk. You potentially could lose your freedom simply by taking a stand for what you believe in, and whether you happen to agree with the person's beliefs or not is really irrelevant. Somebody who has the willpower to face down the potential consequences in order to stand up for what they believe in is a strong person.
The Hollywood Snapshot is you have a Midwestern farm boy who has seen many people lose their land, who again, I remember very clearly, he said, at 15, I was sometimes renting the whole farm. Do you think that that kind of backstory that he presented would offer some of us insight into his character? Someone who's witnessed the small farmer or the mid-sized farmer lose a lot of land and power and become embittered, embattled.
We have, as Americans, I think we have a stereotypical view of people who are strong enough to be farmers or ranchers, and so maybe a bit of that, rubbed off. And I think probably it's probably in this particular case not far off that you have somebody who has strong feelings and is willing to stand up for what the feelings were. And you see that, I guess, frequently when when you think of a traditional American farmer or cowboy or rancher, and that's kind of ingrained in our societal view of people that come from a life where you have to be strong. And so I think there is an element of that.
So, assuming that you're successful, and how fast could you get Hansen out of jail?
Mr. Hansen's set for sentencing in the first part of June, and I don't know that date will change. And so if we are not able to get a release based on the developments from today, then the soonest he would be possibly released would be the first part of June, depending on what the sentence is. There is almost no way to predict what the sentence is going to be, because contempt charges are one of those things where the federal sentencing guidelines don't give a whole lot of direction. It's very discretionary with the judge. And so what we'll find is the judge is going to have a very, very broad range that's probably not typical in a criminal case in federal court, because the sentences are quite frequently bound by the federal sentencing guidelines. And
which a lot of people don't understand, and,
right.
And many people have been quoting pretty fantastic figures for how many years Hogan could get, how many years Hansen can get, without understanding that there are some federal stipulations. But you're saying when it comes to contempt, it could be 2 months, 20 years? Give me some sort of realistic range.
The the range is really completely undefined. And so
Wow.
it is whatever the judge feels is appropriate for the particular case, and then it would be up to an appellate court to review it for whether it's an abuse of discretion or not. And so unlike almost every crime in the federal system, there's a chart, and you can go to the chart and you can figure out how many points you get. And on a contempt case, there's not really a chart or a schedule or a point system, and so it's very difficult to even make a prediction. But the bottom line is that Mr. Hansen's going to get out eventually, and when he gets out, I think he's going to continue the fight that he's been fighting this whole time, whether it's on behalf of himself or Mr. Hovind or somebody else that he feels strongly about their particular cause.
Are you concerned that he'll be under more scrutiny now and might end up back in jail?
There's always that concern that once you get on the federal government's radar, you don't get off the federal government's radar. And so, yeah, I would have that worry about anybody that's been through what he's been through.
Thank you very much for your time, Mr. Klotz.
Thank you. Pleasure to be here.